We're talking about Smith v. Van Gorkom. We left off somewhere at the end of the majority decision in which the court for the first time did something radical. It held accountable the board members for their decision and actually held them to, required them to pay monetary damages for their failure to take due care and notwithstanding what otherwise would be business judgment rule protection. Just want to remind you that the dissent takes the view that at the time was considered to be the obvious position and that most conventional legal scholars still think is the right attitude in this case. And that is, look, this really wasn't a problem. We have a bunch of directors who understood the business very well. They understood business very well. They were all businessmen. They were all, 4 of the 5 of them were CEOs. Another one was the dean of a local business school in Chicago. And these were kind of the heavy hitters in this space. And they'd been directors of this company for a long time, so really knew what its value was, kind of like they knew the back of their hand. They're not the sort of people who could be taken in by the fast shuffle of Van Gorkom. Couple that with the substantial premium. Couple that with a set of remedial efforts made by the board after the first decision was made to reconsider the question, to bring in an investment banker, Solomon Brothers, to bring in lawyers and require some real discussion and deliberation about the case, to put it to a shareholder vote and to have an overwhelming percentage of the shareholders vote for it. All of those things point to this being a good business judgment, one that courts should leave alone. But this argument didn't win on that day in this very important case. As one of the lawyers working on the plaintiff's side summarized it,
based on, these directors were people who had been CEOs of companies and they were solid citizens, and Van Gorkom had been at the company for 25 years. And so the emphasis on that side was, well, all you had to have was a collection of very qualified directors and some managers who were experienced with the company. But the specific issue was the decision to sell the company. Van Gorkom may have known a lot about the company, but he really didn't know what the company was worth as a whole, which is a different thing than knowing the individual parts.
Just notice that part of corporate law, like I think a part of all of law, is focused on, in some sense, the quality of the person, how good of a decision maker we think of them traditionally or typically. And here was a case in which you had people who were considered to be kind of top-notch in our capitalist system, who had been trusted to run business and seen as among the titans of society, and they were being held accountable. And I think that was quite shocking for many people. As you know from the notes following the case, this case would eventually settle after the Supreme Court decided on for the plaintiffs in the case, and it settled for $23.5 million. $10 million of that was paid by the existing insurance, the D&O insurance. The remainder was paid by Pritzker, but Pritzker required that the directors of the company would contribute $1.35 million to charities of his choosing. And so that was the way that worked out. It turns out the plaintiff's lawyer and Jay Pritzker became buddies in this, and later Jay Pritzker hired the plaintiff's attorney in this case to work with him in several ways. But I'll leave that to one side. The key here is that at this moment, the Delaware Supreme Court did something, and that settlement reflected something that was unprecedented. Actual accountability for decisions made by courts based on the duty of care standard that had been in corporate law for decades and arguably much longer than that.
It was the first case in which any Delaware court had ever, in circumstances like this, held members of a public board of directors liable for the way they conducted themselves.
This was new ground, and it was a big deal. And the idea that honest directors of this caliber could be personally liable based on a court's finding that they had been negligent or grossly negligent was a wake-up call to corporate America.
And again, this conception of board decision makers according to their caliber, and a sense and concern that emerged at this moment was, hey, we may find it difficult to attract directors of this caliber to come serve on boards. This could be a real threat to that group of people in terms of operating on these boards of these large corporations. Harvard Law School's Mark Rowe described this as the toughest, most anti-managerial decision to come out of the Delaware courts, period. And at this moment, for this case, Delaware law, at least as conceptualized or understood by those who were subject to it, felt like it was real, that it was a thing that would hold in a regulatory way individuals accountable for their decisions, much as we kind of imagined when we came to this topic originally. We talked about the duty of care and its significance. This was like, say, a doctor being held liable for medical malpractice or a manufacturer being held accountable for a defective product. Only in this case, it was the first time it had ever happened. But was the law really real? Or what would happen? And I ask this question because what was shocking about the case was its uniqueness, but what is interesting about the case as far as we should be concerned is what we can learn from it. One, that it is so rare. And two, what happens in response? Because what happens in response, I think, provides a powerful case study on how the law has always been made in Delaware and kind of how the mechanisms operate. This possibility that law is mere illusion is captured in this cartoon, which was published in response. Kind of a funny joke, but as we'll see in meaningful ways, the law that appeared real post Van Gorkom turns out to be mere Necker's cube, turned the other direction, an illusion of sorts. Okay, so part of what Mark Rowe also describes, and every scholar who's looked at this, is that what happened because of Smith v. Van Gorkom in that 1985 decision would have real implications for Delaware as the seller of laws for corporations. So to put ourselves back in the mode that we talked about early in the semester, corporate law is produced through a process, a kind of competitive process that looks very much like the Burger King have it your way. Come in, buy what you want, and we are trying to serve you in competition with other potential vendors. We are giving it to you your way, but instead of burgers, it's corporate law. And part of what I want to look at today is sort of the mechanisms that typically are not discussed in corporate law classes, but they're just sort of out there. And here we have sort of the sausage, the meat of corporate law, where we think of institutions that are producing corporate law in their relationships to each other and their relationship with corporations and corporate power more generally. So among other things, we have the corporate bar and various corporate bar associations, and in particular, the Delaware Bar Association is extremely influential, including its Council of Corporate Law, in terms of shaping what the statutory response or rules should be and making recommendations to the Delaware legislature, which is very, in turn, responsive to the Delaware Bar. So it's a bunch of lawyers like your future selves sort of assessing what is appropriate for corporations, our customers in effect, and then the legislature defers to that and produces the Delaware legislation in the form of statutes that then the Delaware courts interpret, attempting as best they can on their own also to make their laws delicious for their sellers. And what stands out about Smith v. Van Gorkom, it was like going to Burger King and asking for no pickles. Hold the pickles, but getting one. Right? That the Delaware case really was a shock, and it was unpleasant, and corporations and corporate power responded. They responded because they found it unfathomable and certainly unappealing that corporate law would hold them accountable for a violation of duty of care. So the question is, all right, let's imagine there's illusion of law. How is it going to happen given the institutions that are responsible for producing and applying, interpreting that law? And I'm going to assume in this little model that we're going to begin with corporate power being a given, that we've got power in the system coming from corporations as the consumers of this law, and the state as being responsive to that. And the challenge is, how is it that the state is going to manage to immunize corporate directors more fully than before, and even further than they had before, given Smith v. Van Gorkom, while also maintaining their legitimacy? Because remember, basically what Smith v. Van Gorkom decides is this is an instance in which these individuals engaged in gross negligence. And to have a court come out and say there was gross negligence in this decision that harmed shareholders, when we're also saying that we have to be attentive to managers who might act in ways that are inconsistent with shareholders as our basic macro script, this was a real threat to the legitimacy of corporate law. So how do you maintain that legitimacy? What policies can you enact that will help you with that? And the answers about producing legitimacy, as is a general one in our legal system, including the addition of process and procedure. As we know, process and procedure is one of the ways in which outcomes can be legitimated. See Tom Tyler. Through that, we also employ credible third parties. We, the courts, don't know, but we're worried about this agency problem with corporations, so we want to build rules that ask the corporations to defer to credible third parties. We build processes that then turn to credible third parties and let them decide for us. As long as we see that process, we're comfortable with the outcome, and that outcome is now legitimated. And the other way to do this is to find ways to conceal the effects of the policy itself. So when we think about injustice being perceived when power produces inequality without legitimacy, essentially the role of capture here is to find some way to allow power to continue to operate in ways that produce the inequalities and outcomes, but conceal them and legitimize them. And more or less, that's the process. And then there's, of course, the psychological dissonance experienced by those who are participating in this system, who actually believe themselves and understand themselves to be doing the work of justice, the work of maximizing social welfare through policymaking. So what are their psychological responses going to be? And we've already seen that as well. Typically, it's going to be, look, we don't have a choice. We're a ball. We have to do it this way. So that's kind of what I want to do, but I want to do it not by my telling the story alone, but also looking to them and looking to what they say. And the striking fact that so many of the people who were involved in this lawmaking process themselves describe exactly what I just described. So in terms of process legitimacy, as a starting point, a way of legitimating these outcomes, not holding boards liable for being grossly negligent, the one trick is to insert procedures or processes credible third parties. This idea is that if it happens directly between A and C, where A is the bad outcome produced by director decision and C is the court observing it, there the linearity and connection of those two is too obvious, and there tends to be an association, as there was with Van Gorkom, who had eliminated all the process. And so what do you do to solve that? Well, you require the addition of process. you put in a B, and that B can take many forms, but it can be deliberation. That's where corporate lawyers come in. It can be the insertion of investment bankers. That's why Solomon Brothers comes into this case. Just a little autobiographical note, a bit of a digression. This case is somewhat significant to me because I've been in the roles of the corporate lawyers advising clients. I was mere summer associate, or senior summer associate as they called me, after my judicial clerkship, and advising them on these transactions and how to go about it. I was sitting in the room there, and I worked for Solomon Brothers in 1985 as an investment analyst in a transaction space where I was the one required to put together the numbers to appraise the valuations of deals. So I have an understanding of how that works, and part of my cynicism is born from those experiences. But in this case, what the court wants is to see that process. It wants to see the deliberation, credible third parties like investment bankers or accountants or independent directors. This is a place that corporate law is about to go into. We're going to put the decision in the hands of independent directors, that is, those who are not connected to the inside directors and officers, or special committees. So that's part of what you do. You insert that process and let them get to the outcome for you, and then you can defer to it. So that's part of what Van Gorkom becomes famous for producing a world in which corporate directors will now take the time to hire an investment bank to do a fairness opinion, to value the transaction, upon which they can say, see, Solomon Brothers or Goldman Sachs said this is correct. Now, I'm just here to tell you, it's an open question whether that valuation is going to reflect the interest of the people who hired the investment bank, or whether it will somehow be anchored or tethered to some true value. My sense, it's more the former. It is because of Van Gorkom's effect in creating process and inserting credible third parties to avoid this problem, the embarrassment of a court having to say this is gross negligence because there was no legitimating process, is to have produced what law professors have called the 1985 Full Employment Act for investment bankers, lawyers, and accountants. Or as another one called it, the Investment Bankers Civil Relief Act of 1985. Why? Because now with every transaction, boards are going to bring in these people to advise. Those people are going to charge money, they're going to bill hours, and everyone's going to be happy. Who can afford this process? The wealthy, large corporations. It is a non-consideration. Of course they're going to do this. It totally makes sense.
People talk about Smith Van Gorkom as the Investment Bankers, Full Employment Act or something of that sort. But in a sense, maybe it's also the Delaware Lawyers Full Employment Act.
If a board conducted itself in the same manner today, I think you'd have the same results. I think boards are a lot more careful these days and get a lot better advice, and often get advice of Delaware lawyers early on rather than only after a suit gets filed.
Right.
Again and again, we're told that corporate laws, you don't have to worry about the decisions because these parties are involved and they're on the bully pulpit. And again, I ask you to question whether young lawyers or the lawyers that are participating in this are really putting up meaningful resistance and changing outcomes, or more or less working on behalf of their clients and the most powerful members of their client base to serve them and what they want to do. The next thing that is a response to this is the court wants to do more than just legitimate the outcomes through adding process. They want more immunity. But they can't just say, guess what, everyone in the world, every time there's gross negligence, you get immunity. That is just a bad look. So they have to consider what are some options, given that they have already established a set of immunities, including the business judgment rule itself. So they're operating within certain limitations. One option is to say, let's just let board members rely on insurance that will compensate them, so there's really no threat to them should they be held accountable in a duty of care violation. The problem with that story is that insurance already existed at this moment. And so they couldn't change the existing market to make it provide more coverage, so they felt it was inadequate. Furthermore, it was still an expense of the corporation itself. Like, they still have to pay for that insurance. And it is often limited in terms of how much it provides in terms of co-insurance, co-payments, and caps. Indeed, in this case, we know the directors and officers insurance was capped at $10 million. With a $23 million settlement, that seems inadequate. Prices of insurance at this moment were going up. Scholars have shown that it had nothing to do with Van Gorkom as a decision, but with the cycles of insurance markets themselves instead. But nonetheless, that increasing price made insurance less attractive. And also, insurance has this ugly effect of covering expenses that would make corporations more viable as targets of lawsuits. Because now a shareholder suit comes in, they say, we think you did something wrong. Board wants to avoid the hassle. They have insurance. They may want to settle because they've covered it. So it in some sense, softens and makes more attractive the target itself. What about caps on damages? Just like we've been seeing in punitive damage range in the same time period. For tort law, why not put caps to put a ceiling on how much directors might be liable for? The answer was, well, that's better, but it's still an expense, and plus you have to decide what is the cap. And to the extent it's not low and very low, there's still an incentive to bring a case. And worse, if we start getting involved in this cap business, another one of our states, another one of our competitors may get in and lower the cap. And they may beat us, in which case we're playing this cap game and other states are making themselves more attractive because it's easy advertising to say we've put the limit at 1 million instead of 10 or 100,000 instead of 1 million, etc. Here is the description in their words of this possible policy option.
I know that in April of 1986, a prominent lawyer sent you a proposal that dealt with a damage cap of I think it was $1 million at that point. What was the reaction to the general idea of damage caps?
Well, there was mixed reaction. Obviously, there were some who were enthusiastic about it, including, and it was more than one that sent us a proposal along that way. There were just as many who were concerned about it for various reasons. One reason was that nobody could agree on what the cap ought to be. $1 million, $100,000, and that would obviously have different impacts depending on how wealthy the director was.
Do you recall much about the discussions concerning the desirability of a cap on liability for directors?
I don't, but I think that was shot down pretty readily, as I recall. Because if we put a cap on, then some other state would put a lower cap, and then pretty soon there'd be zero cap, and it's that kind of thinking, the sort of parade of horribles argument that it would not help matters, it would make it worse, in fact.
We are peering into the deliberation process of the corporate bar that was responsible for producing this policy solution to this problem posed by meaningful director accountability. And what we're seeing very much is a kind of Burger Kingization of analysis, which is we've got to avoid doing things that other states can beat us at. Apparently, from their own description, we're to conclude that specifying a liability cap is more arbitrary than eliminating all potential liability, which is ultimately what they did for certain kinds of due care violations. And that the so-called parade of horribles about which they were frightened was a race to the bottom, which Delaware was willing to compete in fact had been winning, and they decided to just win this one by going directly to zero through their actual policy response, which, as you know, is 102B7, which we'll get to later. Okay, so there's another option. What about expanding indemnification? Why not just allow these suits to happen? There may not always be insurance. We're not going to get into problems of caps, but we're going to allow corporations to indemnify directors for any of their expenses, including their damages for gross negligence. Well, that sounds good maybe to the directors, but first of all, it's expensive. Corporations still have to pay for these damages. Second, it maintains the incentives to bring these suits because someone is going to be paying for them and they're there. And most importantly, that just looks really bad. The optics are really bad. And I'll let these corporate lawyers explain their own thinking about why this was a non-starter.
That solution had big policy problems with it. That's a circularity thing. If you think about the public perception of a trial occurring, an appeal occurring, and directors being found liable and told by the court that they were obligated to write a check, let's just hypothetically, a check for $10 million to the corporation for whatever misdeed they had done, whether it be a loyalty violation or a care violation or whatever. And then the corporation is permitted the next day, after going through a process, to write a check back to them for the same $10 million. That just is an unviable concept.
I think the council took a very responsible attitude toward all the issues that came before it, but particularly this one, and they just didn't want Delaware to appear to abandon all rights of corporations, shareholders, investors by just saying to directors, you do whatever you please and we'll indemnify you, and you have the circularity problem, which we're all aware of.
Circularity meaning the corporation, there would be a damage award in favor of a corporation, which the corporation wouldn't ultimately have to pay.
That's correct.
So hear what they're saying. They're saying we didn't like indemnification, but we did like 102B7, which was a complete waiver of corporate damages or director damages for any violation of duty of care, because indemnification looked bad, because it seemed to leave the directors unaccountable. And so it would be perceived as a problem. As Gil Sparks put it, think about the public perception and this circularity problem. That doesn't look good, and it'll be very visible because there will be a finding by a court that indeed directors had been grossly negligent. There'd been a misdeed identified. And then following that, the corporation would say, yes, and now we're going to pay the director for the misdeed. That's just too public. And it's for that reason that Gil Sparks, it's an unviable concept. Because of its visibility, not because of its policy implications, but because how it would be perceived. Joseph Rosenthal put it this way: the council didn't want Delaware to appear to abandon all rights of shareholders and investors by just saying to directors, you do whatever you please and we'll indemnify you. What we instead wanted to do was to say, we're going to abandon all rights of shareholders, do whatever you please, and don't worry, there'll never be a lawsuit. One is more visible than the other. It's better to abandon shareholder protections before there's a salient misdeed in the press that goes through the judicial process and is named as such by a court. One that is hidden in the corporate complexities of the corporate statute, 102B7 for crying out loud, and in the corporate charter. It just is. We know it, corporate lawyers know it, but the public doesn't know it. Then to appear to abandon rights of shareholders in public after misdeeds through public judicial processes. That is why indemnification was an obviously bad option, but waivers were a good option. It's about concealing what's happening. 102b7 then becomes the perfect response. It's cheap to implement. Basically, just put it in the charter. Shareholders presumably will vote on it at some stage. It disincentivizes lawsuits, so you're going to get fewer of those in the first place because there's just nothing to get. You've made yourself judgment proof. You're legitimizing the outcome by putting this to shareholder approval and getting the legislature itself to approve it. And it's all concealed out of public sight in the statute and in the charter. Meanwhile, we still have a jurisprudence that claims, as our casebook does, that the duty of care is real. Read the first sentences of the duty of care section. And finally, because we learned something, there's still some limits to 102b7, some circumstances in which courts will allow a case to be brought because 102b7 will not apply in certain circumstances. And as you know from encountering the statutory language, a corporation may not eliminate liability for any breach of the director's duty of loyalty. And here we're talking about loyalty. We're talking about something that's much more dispositionist. It is a stickier situation, as they say. Or acts or omissions that are not in good faith, again, dispositionist, or which involve intentional misconduct or knowing violation of law, again, dispositionist, more sticky. Under Section 174, which involves unlawful payment of dividend or unlawful stock purchases. So there is, again, the kind of dispositionist foundation here. Or for any transaction from which the director derived improper personal benefit. So when there are these salient examples of bad apples operating on the board, we still have a cause of action for which there could be damages. But for negligence in the decision-making process, we have eliminated liability. Now, there were those involved in this process of making this law who opposed it, including some very powerful people who saw it within Delaware as problematic. And I want to say a little bit about two of them because they figured prominently in the debate. One was Senator Thomas Sharp, who was president pro tem of the Delaware Senate, who didn't want this to go forward and was resisting and trying to drag his feet and push back the timing of this, thinking it unseemly to be removing any possible liability of directors for gross violations of the duty of care. And Bruce Stargett, who was a member of this Council of Corporate Law section, an influential member of this group that was charged with analyzing policies and proposing them to the legislature. Bruce Stargett's story is particularly interesting because we have some original documents, including his dissent that he wrote to the council itself on May 7th of 1986 when this statutory provision was being considered. And in that, he says, I am in strong disagreement with the proposal. Listen, people, before Smith v. Van Gorkom, we were all on board with the duty of care. I heard not even a faint murmur of the dissatisfaction with the duty of care. And now the first time someone has to pay, we think there's something fundamentally wrong with the duty of care. The reasons now expressed by those who feel themselves obliged to allow its elimination are pragmatic. And what Stargett is arguing is that we should be principled here, not pragmatic. It's said that a group of Delaware, now he's reporting in his dissent, what are the arguments that are being offered for this legislation. It's said that a group of Delaware corporations will introduce legislation which will be worse than what we're proposing. In other words, they're going to do it even if we don't. It will be worse. And now we're saying we're balls. We have to do this. It's the best we can do given our double bind, given our circumstances. And that will then engender an unseemly debate, which would look bad for Delaware and its legitimacy. But says Stargett, no, my reaction is that if it's worse, we should oppose it. That's our job, right? I thought that's what we were saying was our job. To pick the best law for Delaware and not do what we're driven to do by corporations who are pushing us. And we should be totally willing to debate it. Let's have the debate. Because if you debate it, those corporations themselves are likely to lose, because it looks like, quite visibly, they're just trying to shield their directors from liability for their own gross negligence, which is not going to look good publicly. It's a hard argument to make in public. So we should do the right thing. He then finishes by pointing out that this idea that seems to be motivating the council, which is that we want to keep our market share from other potential states, itself is too close to what Professor Carey complained about when he complained about the race to the bottom. This is a quote from Carey that as long as we operate within a capitalist society, as long as confidence in management is prerequisite to its continuance, the absurdity of this race for the bottom, with Delaware in the lead, tolerated and indeed fostered by corporate counsel, that's us, says Stargett, should arrest the conscience of the American bar when its current reputation is in lowest state. Our reputation as a profession is also at stake. We should not be participating in this de facto race to the bottom. Bruce Stargett's opposition was firm. You might even say strident. And it was a real concern for the council because they didn't want this debate to go public. And so here's an account of what happened.
I had received a call from Charles Welch. Charles Welch was then the general counsel of the DuPont company. And he, along with the Squig Group and really most major corporations, had been following all this with some degree of interest. They recognized that what we were doing was much better than the situation they were facing otherwise. And so we seemed to have general support from the corporate community. We knew that by the time we had gotten to this point. Mr. Welch had asked for the privilege of speaking to the committee. He was homesick, but asked if he could speak by speakerphone. He did that and explained that he also knew Senator Sharp well and was hopeful that Senator Sharp could be persuaded to permit the draft bill to be introduced and voted on in this session. And then he went on to say that if for some reason we didn't introduce it, he would introduce it independently, and if the bar didn't, well, that was a fairly strong statement. And all I can tell you is that between May 28th and June 2nd, Bruce Stargett dropped his opposition to the bill. He wrote a letter, which is in the file, explaining that he wasn't wholeheartedly in favor of the bill, but they did understand the traditions of the bar and that he would, under the circumstances, withdraw his opposition. Now, I'm not going to speculate about what sort of interaction there was between, and whether he was persuaded by the meetings that we had with him, whether he was persuaded by Chuck Welch's position, whether Senator Sharp was involved or any of that. I have no idea. All I know is that by the time Memorial Day was over, the horizon was brighter and I was happier.
And so that's how it went down. Jack Welch talks to a group of the council that includes Stargett. Jack Welch is the general counsel for DuPont, which is the largest, most significant corporation in Delaware. And he leans on him, says, look, we're just going to bypass you. We're going to do this ourselves. And shortly thereafter, the opposition of Stargett and the Senator Sharp fell aside. And there was indeed a memo, and this is what Bruce Stargett had to say. I will withdraw my legislative opposition to the corporation law section proposed. This is a few days after the meeting just described. In the weeks since then, my first letter, many of my friends have called and visited to persuade me to call off the fight. Most recent was the meeting with the small delegation of highly qualified lawyers. This is the one that was just referred to, with Jack Welch involved. Stargett explained that he changed his position because he was convinced that changes to our general corporation law have an unbroken tradition of unanimous support by the bar. So now look who's being very pragmatic and not particularly principled on this decision. Stargett is deciding to refer to the unbroken tradition, he didn't change his position then because of the suggestion that it would be unwise to press forward in Dover because he would suffer financially, which was something that was suggested at that meeting, that it would be in his financial interest to go along with it. No, he emphasizes, I wasn't moved by that pressure, nor was he moved by the arguments on the merits. I thought and continue to think that the proposed amendment to Section 102B7, allowing directors to be immunized from the financial consequences of their gross negligence, is just wrong. So it wasn't on the merits. Why did he relent? Because these differences of the sort that we've encountered have traditionally been ironed out by the council itself, and before that by the Corporate Law Committee. The result has been that the General Assembly, the legislature, has come to have confidence in the strength of our recommendations, representing a consensus of those professionals most familiar with the needs of Delaware corporations and their stockholders. Our legitimacy as the Delaware corporate bar with influence over the legislature is at stake. To maintain that, I'm going to get into line and to be obedient, and I'm going to do what has typically been done in these cases a few days after the Jack Welch conversation. Now, it's true that resisting as I had planned might have the virtue of fostering democracy in its pure sense, but in years to come it could prove worse in its practical results than the passage of this one bad piece of legislation. So he sees this as just a cost for a larger benefit. He's being extremely pragmatic and seeing himself very much as Ball. And here we have Justice Norman Vesey, who was a Delaware Supreme Court justice, explaining this relationship and why there has been this relationship between the corporate bar and the corporate legislature. This would be the kind of argument that Stargett would have been presented with when he was opposing the bill.
For the most part, these amendments presented to the Delaware General Assembly have gone relatively smoothly because the members of the General Assembly who focus on this know that the Bar Association Council, Corporation Council, has spent a lot of time in debating these things and examining how they are perceived all over the world, because Delaware's corporate franchise is the most important asset Delaware has. And it's very important that we keep that ship on an even keel. And they know that, and they know that we and the Delaware Bar Association are paying attention to that, and that we do a balanced job that's been vetted throughout the country. So they usually take what we say, as being carefully vetted.
We're getting a sense then from the discussion of this case of the nature of the relationship between the legal professionals, the Delaware Bar representing corporations in Delaware, the Delaware legislature representing the Delaware state interest in its desire to maintain the budget privileges that come from winning this race to the bottom, and the Delaware judiciary that sees itself part of this larger system, this ecosystem of collaborating to keep corporations coming to Delaware. With Smith v. Van Gorkom being a temporary disruptor, and 102B7 being a return to the homeostasis of us winning this race. What I want you to understand is that 102B7 struggled with its legitimacy in part, but also behind closed doors. Its legitimacy was maintained in part by the shared consensus, the unanimity of the Delaware Bar, the endorsement by the legislature, the understanding that we're all part of this system, and the processes that were added as a consequence of all of this. One of the elements of legitimacy was the shareholder vote itself. And part of what you want to think about is, what effect does the shareholder vote really have? What does it really prove something we'll return to later in our final week.
Was it important that the stockholders have a point of view or a say in exculpating directors for negligent acts?
Yeah, the proposal was to either have it in the original certificate of incorporation or in a provision in the corporate documents that the shareholders would vote on. Mm-hmm. And that's the way the proposed legislation was written. If the stockholders wanted it, that's fine. Realistically or pragmatically, that's really not satisfactory. You've got a large corporation, and they solicit shareholder approval. You know, shareholders generally did what management or approved what management proposed, but nonetheless, it was the shareholders saying this is okay.
So just to repeat, realistically and pragmatically, shareholder approval is meaningless. But nonetheless, as he described it, there's still shareholder approval. So what's the point? That provides this legitimating consent from the very group that we say corporate law is intended to protect. And so with that as the process and that sense of this being in the interest of corporate boards, it was adopted and it was widely adopted.
At the overwhelming reaction of most of the stockholder base of the Delaware corporations to Section 102B7, and it went through very well. It's been adopted almost universally.
And as it turned out, literally, I mean, and not every corporation, but a huge percentage of corporations put this on their ballot, if you will, for the next spring's proxy season. It was just a routine proposal, and I don't know of any corporation where the proposal was rejected. And it's since become a rarity to find a public corporation in Delaware that has not adopted 102B7 in a full-throated way.
So that's the response. Roughly a year after Smith v. Van Gorkom, this disrupting pickle that was placed in the burger when the customer asked not to have a pickle. What we have is a system that's more or less eliminated pickles. And it's been adopted almost universally without meaningful resistance, in part through shareholder votes, which we acknowledge are more or less meaningless. And that is how corporate king has maintained its dominance in the race for providing corporate law. And it is this relationship of corporate power over these various institutions, which are themselves serving as credible third parties. And very importantly, corporate lawyers are part of that process and seem to understand themselves as part of the process. Here is their summary.
Well, 102B7 basically came out of Smith v. Van Gorkom.
Right.
It was a reaction to it. And, you know, the idea that, because after the Supreme Court's opinion came out, then, you know, the question was, were these directors going to be personally liable?
Pragmatically, there were two threats not on the horizon. They're really in the forefront of what was happening in corporate, I call it corporate America, but that includes the legislators. One was the threat that other states would jump on the problem and make life much easier for corporations and directors to do business in their states. So if we wanted to retain the primacy of Delaware, we better do something fast. The second theme was there was a considerable movement on the part of corporations to propose their own legislation to the General Assembly, which is just an unheard of thing in Delaware.
And the council's role in connection with the corporation law was what? How would you describe it?
We drafted and recommended proposed legislation to the Bar Association as a whole And then that proposal, if carried, would go to the legislature. And I'm pleased to say that the legislature respected the recommendations of the council and the bar, and was very, how shall I put it, let me say, welcomed, our contribution to the development of Delaware corporation law.
I thought the deliberations, the respect for various views, and the way we got to a solution in the end were the epitome of how I would hope that the council would always act, and to my knowledge pretty much has. I think this was a good exercise in terms of both reaching out, getting views, respecting other people's views, and coming up with a solution that really worked.
That's the process by which the corporate sausage is made. Now, you might think to yourself, who cares? It's just duty of care. It's just shareholders. No big deal. But remember, many of the big duty of care cases have involved instances of decisions that have harmed others than shareholders. Think about the sort of business judgments that were being made by Enron, just to give us an example that we're really familiar with. Or Alice Chalmers and their antitrust violations. Or the monies that were lost in various cases where duty to monitoring was at stake. We're talking about laws that are purportedly governing meaningfully managers on behalf of shareholders, which in fact are often illusory, to justify what is going on with respect to other stakeholders, including what's happening on the planet and our environment. And so that's why Allen and Crackman, in summarizing this law pretty perfunctorily in their introduction, look, we had this change in law in 1985, authorizing companies to waive director and sometimes officer liability for acts of negligence or gross negligence.